Maybe I should have had that on tape, huh?
Okay. All right. So we're back for the next round here, discussion, Q&A, Mr. Spencer. And let's just point out again, for today's purposes and for most of the folks that are here, are kind of really fresh and new and starting from basic ground level. So other folks maybe might be tuning in, have a broader understanding of some of this stuff. Anyway, we just wanted to reiterate that again. Because it's like a lot of the folks that are here could appreciate been studying various other esoteric topics, and especially the ranch is really well known for having our niche in ufology and exopolitics and that sort of stuff. If you were just first starting to hear about Palladians and Andromedans and Syrians and stuff, you never heard about it before, it might take you a little while to start to wrap your head around it. So
That's me?
just to get, flip the tables, But so we're going to open it back up to Spencer. Maybe before we get into a bunch more questions, though, Spencer, could you maybe share with us some of the experiences that you've had? You had a great story about going in to court and basically defusing it with essentially one question.
Yeah. I went to a court for a traffic issue way back when I just first started learning this stuff. And I was the last one to get there. The judge asked, is there anyone who I haven't called yet? Right as I'm taking my first step into the court. I said, right here. He said, come on up. And so there were two charges on the ticket, on the instrument. One was no license, and the other one was something else. I don't remember. Two charges. And so right when I got to the center podium to talk to the guy, the judge, he read whatever the charge was and says, well, how do you plead, guilty or not guilty? And I said, well, there's this charge and there's this charge. I said, are you asking me to plead guilty to the first one? Or are you asking me to plead guilty or not plead to the second one? Or are you asking me to give you, or how can I give you one answer for two questions? Case dismissed. It happened so fast I almost didn't quit walking because that conversation happened while I was walking up to the center. And he looked in a book and looked up a couple things, and probably just for the benefit of everyone else in the peanut gallery, because now if he just instantly knew that was a checkmate, you can't show that to the audience. So he kind of made it look like there's conditions and criteria that also need to be met. But who knows what was in his mind right now. I'm just speculating on that portion of it. But he's case dismissed inside of 20 seconds. And I just turned around and walked out.
Wow.
Yeah, in and out.
You're just going, what just happened?
It was great. And you know what? I got a little flippant on the way out. When he said case dismissed, I said sold, like I was at an auction. Oops. Yeah.
I was wondering if you could elaborate on that. What do you think that happened? What is it about the question he asked that the judge didn't want to get into?
To plead guilty or not guilty is a single answer. Where do we attribute it? Where are we attributing that answer in his question? So if I ask you, Frank, do you want ice cream or would you rather do you want ice cream and do you want to go to the fair? Or how can you give me a single answer for two different things? Because maybe you only want half of it. So if you say yes, but you don't want to go anywhere, but if you say no, you want the ice cream, it's a logic fallacy. It's a non sequitur. That you can't assign a single answer to two questions. And so it's up to him to decide a matter. I mean, he can't recreate a traffic ticket and say, okay, well then here's what we're going to do. We're gonna recreate two instruments. He's a disinterested third party, and so I can't, it's impossible to give him that answer. He can't process it. And so he's not my adversary. At the same time, he's not my adversary, technically. In that case, he is, but he shouldn't be.
But he could have asked you one question at a time, right?
Yeah?
But he didn't do this.
Right. Right. But that would have meant two cases then, right? How do we have two cases on one instrument? That seems like a double jeopardy issue.
So what if you go in and you say, like you play his game, you say, I plead guilty to the first one, but not guilty to the second one?
I don't know. I'd have to think about it. He would probably roll right over the top of me with, we're not here for that. How are you pleading? You know, who knows?
Because one time I went in and I had I couldn't find the proof of driver's insurance.
Yeah.
So the cop wrote me a ticket for it and a speeding ticket.
Yeah.
And I went in and said I plead guilty to the speeding ticket, but I have the proof of insurance, so I'm pleading not guilty to that.
So he dismissed it separately.
Well, he did, but when I showed him the proof, he said something that was along the lines of, well, the court will just take your word for it and I'll let this one go. Like,
Yeah.
I didn't-
He could have had a lot of solutions around what I did.
Yeah.
He could have. I don't know. Yeah.
So are you saying that the two issues were the two different charges, or the two issues were the two different questions? Are you guilty or are you not guilty? Are those the two questions?
No. The two questions are whether or not to answer guilty or not guilty to the first charge 1, and charge 2 is a second question, right? That gives rise to guilty or not guilty to this.
Okay, so this is only applicable to something that has multiple charges.
Yeah.
That this certain.
Yeah. That's just what I did. I don't know that this works across the board all the time, and I've thought it all through. I'm just, here's one thing that happened.
Did you enter the bar? Because I hear that if
Oh.
you enter the bar, you're in the jurisdiction.
Absolutely. I did everything wrong.
You did everything wrong.
Yeah.
So
Yeah. Yeah. Yeah.
So would you tell us a little bit about that? What's the difference about entering the bar? You're talking about the gate at the courtroom.
Yeah.
What does that signify when you go through that gate, or if you transact all the business behind that gate?
If there's an ancient concept that goes back to merchants and traders that you know, when you're doing business at these seaports, international seaports, different rules and regulations and customs were practiced by different groups, different nations. And so some countries you just didn't want to do business with because you couldn't find remedy. You know, maybe you just didn't like the way Egypt did business, or you know, whatever the country is, right? And so you knew what rules that they went by based on the flag they were flying. If you wanted to do business with these guys, you'd look at their flag, you'd look right in your book and say, okay, you know, where do these guys, you know, where do these guys fit on the, you know, resolution of trade? How easy are their judges to deal with, you know, if there's a problem? And that was always signified by a flag. So when you go into a closed off area like this court and they have a flag flying in the background, that's the presumption that we're going by these rules. And you're very restricted and limited. So a lot of people say, I'll enter the bar without waiving any rights and reserving all, you know, whatever you say undoes that presumption of the flag. Or the rules, you know, federal rules of civil procedure, whatever the finite rules are of a particular venue, can be negotiated before you go in. Or otherwise, if you just walk in, they give you fair notice based on the flag. Hey, this flag goes by these rules. And so there's a little bit of some backwater research and issues with guys kind of being a little bit excited about what does this gold fringe mean around a flag. And, you know, the U.S. flag technically shouldn't have a gold fringe around it. You know, so why do courts and cops have it on their shoulder?
So do they? Because it's set up in the maritime format.
Mm-hmm.
That's what the gold border represents.
Mm-hmm. Right. Right. It's
So like all the sailing ships back in the day would have their gold fringe around them.
yeah. You know, I don't know that for sure. I haven't looked into that much myself. Something I've heard that I can't verify as to it being reliable or not was that a bordered flag means that it's been captured, and it's now under it's now an entirely self-contained entity, but it's captured and held by another entity.
That brings up all sorts of interesting thoughts. So.
Just going back to going through the bar, people have different perspectives on that. Some people do go through, some people try and do business all behind the bar.
Yeah.
So I know that there's, like all of these things, it's not just one way to do it correctly.
Right.
There's several ways that we might, that feel right for our own personal method.
Yep. That's probably most important.
But essentially, from your perspective, what you're saying is like, it's important, if you're gonna walk through the bar, probably put your conditions on that
Yeah.
before doing so.
Yep.
And just do it really simply, too. Like,
Yeah.
I think is what you said, is just maybe,
I don't.
I don't waive any rights, and
Yeah.
rebut all presumptions. and
Yeah.
walk through.
Yeah. I don't agree to any unstated presumptions.
Yeah.
Unstated.
Yeah. Yeah.
So, sort of changing topics a little bit, there's an awful lot of people out there who are standing outside of financial districts with signs, and they're all sort of interested in a solution such as this. Have you toyed with some sort of projected possibilities of what would happen in our country with the financial and banking system if enough people came to be familiar with this new code of conduct? And what would you say to a person standing outside with a picket as the most effective thing that they can do to affect the change that they're trying to create?
Yeah, the banking system doesn't produce or create anything. So if you just think about the revenues that it generates, it's purely parasitic. So whatever kind of commercial energy that a bank absorbs, what would happen if this system went away, everyone was competent and capable of handling their own commercial affairs, it would just redirect that currency out into something else, hopefully more productive. And what would I say to someone? What was the next one? What would I say?
What would you say to somebody who's out there who's like the standard American, who's got their student loans or their mortgage, or they've got a reason to be upset and to be out there on the street corner, and they represent such a small percentage of people who actually feel that way. And what is like their next most effective step into learning about creditors and commerce?
Yeah.
What's the first resource that you would say would be the best resource for them to start understanding and to start taking really effective steps? And how, I guess, sorry, I'm tacking a little bit more of a question on that.
Yeah, I'm keeping up.
How do we share this? Is it like...
Well, okay, I got it. I saw a guy protesting somewhere near Seattle one time, and he was so upset he almost couldn't contain himself about some of this stuff. And so the first thing that popped into my mind, who knows if I'm right, was he probably has just started to learn about some of this stuff. And so I asked him, I said, and you feel that a lot of these things are a problem? And he said, yeah. And I said, do you think it's a big problem? And he was just animated, yeah. And I said, well, let me ask you this. How much have you looked into what the remedy is? And he was shocked at the question. I said, how about you go down that path? It's not like I'm not aware of it. But I'm also aware that there's remedy out there. And it's all I thought I could do with the guy. I don't want to have a long, drawn-out conversation about something he doesn't know about. So I just left it at that. And so the best way to be able to pass this along is to be somewhat proficient yourself. I mean, how do you explain something you don't have the conviction and knowledge to fully explain. And you got to just be able to do it. You know, and that's...
So if somebody was out there, what would be a resource that you would point to first? Say, go there to start. Where would you suggest somebody go to start learning about this stuff?
That's here's the problem I have with that, is that's an answer to a question they're not asking yet. And so the best way to do this, I would say, is to start that conversation as to where is your question, where's your interest on this stuff? Because maybe it's driving related issues. It's not purely commercial. Maybe it is the credit card issue. You know, I would fine tune it because they have to follow their own question. If you just blindly give people answers to questions they're not asking, it has a probability of falling on deaf ears.
Oh, excuse me for interrupting. This is such a broad and varied area,
yeah,
is what you're saying,
yeah.
that there's so many different specifics that other people like you are focusing in on explaining for others.
You got it. You got it. Commerce is like someone asking, how do I fix my car? I don't know if we're talking about pistons or the electrical, or maybe there's something wrong with the upholstery, and all those things are certainly related in the confines of a car, but I mean, there are companies out there that only do upholstery, you know, and you couldn't just go in there and know it, right? It's deep. So the same thing with this stuff, you know, the nature and character.
I'll ask you on a specific subject, I suppose.
Yeah, yeah.
Who would you suggest would be one of the better people for, say, credit card debt?
Creditors in Commerce.
Resolving debt.
CreditorsInCommerce.com. Creditors in Commerce.
Jake, write that down.
But my search through the internet for these sources is not very deep. I look for specific answers, and they're very good at a broad, general, let's get you started on this thing type of information.
Great. I have about 3 questions, but I'll try to keep it brief. One thing I've seen over and over again with this society, you know, they say that there's a form of insanity, which is doing the same thing over and over again, expecting a different result. And so we're going to the lawmakers and the politicians and everything else trying to get a different result, but we get the same result every time.
Mm-hmm.
You know, we're just the people getting screwed.
Mm-hmm.
And you know, I don't want to put all politicians or all lawyers or whatever. There are some out there, but that they are constrained, you know, by what they agreed to. But I'm seeing over and over this is a whole different approach, and people need to break that program. That it's almost like an habitual addiction.
Mm-hmm.
That they've been programmed into, you know, using the same old methods again and again. You know, one example I use is like everybody's waiting for Obama to tell us UFOs are real.
Mm-hmm.
You know, and signing all these petitions, and they're going to NASA and saying, "Come on, tell us UFOs," and it's like going to the Liars Club trying to get truth.
Right. Right.
So, I mean, why do we keep doing this? Is what just blows me away. Why do we keep? It's such an ingrained program, fear-based program. I guess they use fear to ingrain this so strong. How do people break that program rather than just getting burned over and over again?
Yeah. Man, what comes to my mind when I think of what the government does for most people is that they've very much engaged in a guardian-ward relationship and they don't know it. You know, another way to say that is a master-servant relationship where people are very happy to look to someone else for their own solutions. And it's kind of also the difference between a republic and a democracy, right? A republic is you're competent to handle all your own affairs. I might need someone to be a post office or a judge to, you know, adjudicate a little bit of a disagreement over here, but, you know, thank you very much, I'll take it from there. And the other side is victim. It's, I don't know how to do this, you do it for me. And so I think once you kind of start to to entertain those concepts, the reliance on why you even care if what Obama says greatly diminishes.
Yeah, I agree. Now the other one, there's a woman I've seen, she's been just sticking to one question over and over again. I'd like you to comment on that. When she goes to court, she just says, where do you derive your power? Where do you derive your power?
Uh-huh.
And they usually just throw it out.
Uh-huh.
And she just holds that one question up.
Yeah.
And it's my understanding that the state is a corporation.
Yeah.
And their employees are trustees.
Yeah.
That's their position in the corporation. And our position would be beneficiary or director. So basically, if you went to court and say, where do you derive your power from? And they were to say, the state of Washington. And let's say, the state of Washington, you say, what position do you hold in the state of Washington? And they say trustee or employee. Then you can say, well, as beneficiary and director, I'm charging you to dismiss this case, with prejudice or,
Yeah.
or whatever.
Yeah.
That's another approach. I'd love to hear your comment on that.
Yeah, she's making a distinction between a judge and a magistrate. I'm not a real fan of statutory, but I kind of like that one. I might have the numbers wrong. The people of this state do not yield their sovereignty to the agencies that serve them. And so it's not often that you get the state itself to acknowledge that. Whether or not the fact is there doesn't mean that they'll consider it. And that's a statute that there's nothing else in it. The people of this state do not yield their sovereignty to the agencies that serve them. So, she's kind of saying the created cannot become greater than the creator. We're back to status again. So if people or men and women created government, and government created citizens and persons, they truly do have, government does have dominion over their creation. So you can't, to argue that is fairly irrational, but when you know it, you know where your status ought to be, man or woman or people, we the people, created, ordained and established. Well, if you're one of the people, you're not a person. So it's just understanding who you are.
So that would be a viable approach.
Yeah.
It seems to be doing really well.
Yeah, yep. Yeah, you could maybe make it so ambiguous that you're having a tough time having an intelligent conversation with the judge, even though you're right. There might be ways to, understand it a little more and clean up the conversation a little bit so you can get somewhere with it.
So just by quoting that law or whatever and then stating it.
Well, I don't know that I'd quote anything. I mean, I like to know what and why something's said and then articulate it in my own words.
Spencer, here's how I was kind of thinking about it. And after having a conversation with Dean, he kind of gave me this sort of framework to look at this. You might go in and say, okay, well, even this is a statute, and I'm not saying that I'm bound by this statute, but even if I was, according to your own statute right here,
Right.
clearly says that
Yeah.
we're not bound to be subject to
Yeah.
to your authority necessarily.
Right.
We don't give up our sovereignty.
Right.
So I'm not saying I am bound by it, but even if I was, or even if I'm not,
Right.
by your own rules.
Yeah. Well, here's another way to look at it too, is once you know your status is above the government, and people created government, isn't that part of your creation? And so now all of a sudden that's your statute to use and choose as you want. So you don't have to be too afraid of a statute. You don't have to be too afraid of it. Just know where the pecking order is.
I guess you can say that you can choose to use the statute whenever you want.
Yeah. Yep. Yeah.
It doesn't mean you have to just, once you do choose, it doesn't mean that
Mm-hmm.
you're bound by it forever.
Right.
You can pick and choose
Yeah.
the time and when or how.
Yeah. Yeah, yeah, you know, and to use these statutory courts too is a benefit privilege. If you want to go, let's say, sue somebody over an unresolved debt with a car that you sold, to use that court is a benefit privilege, and to get an adjudication it is also a benefit privilege. And so I think we forget that to be sentenced for a crime it's the same thing. It's a benefit privilege. I don't remember if we talked about this or not, but if it came time to a point, you know, where you just lost every which way and something was adjudicated, you could just waive it, because why are you obliged to accept a benefit or a privilege? Right? That's something that's up to your discretion. So you could, you know, waive it. I waive that. You know, we sentence you to 5 years in jail. Well, I'd like to waive that. I can't remember what they call that. At the end, it's called allocution. At the point of allocution. You got to be on the record, though.
So you say if I waive that benefit,
Yeah.
is there a way of
Yeah.
expressing that?
Yeah.
Like I waive that benefit?
Yeah, yeah,
So,
yeah. Yeah, I would just say I waive it, and if they tried to get too aggressive about not being able to, I would just say, well, will you state for and on the record to accept an order or anything from this court is not a benefit or a privilege? Will you state that for and on the record? And then, you know, now they might have some new context to think about that within.
Yeah, I've got a question kind of just related to what you just said. You know, clearly from my basic research into this, one of the prime techniques that they, in inverted commas, use is pressure.
Mm-hmm.
And it's the fact that you're in the courtroom, there's loads of guys in nice Italian suits or whatever.
Right.
From, you know, Target, who knows. But they're all sat there, you just want to get out of there, you're kind of maybe not sure what you're doing. Even if you do have this layer of knowledge and awareness that yourself and people like you are sharing,
Mm-hmm.
what is one to do when they just sort of steamroller through that and say, look, I don't know what you mean about this notice, I don't know what you mean about honouring this song.
Yeah.
You just need to pay the bill. Are you going to pay it or not? What happens when they just steamroller over your knowledge? How is one to perceive that?
Yeah, due process rolls around to such a fine point in conversation that we can defeat that. But before we get there, I'll hit on that. One of the things that I try to, and this takes effort for me, but I try to get myself in a mindset where what they say doesn't have any effect on me, and none at all. And I really envision the movie What About Bob? Have you seen that movie? So no matter how bad things get for this guy who's a mental patient with a doctor, he's just pumped about it. Finally, to the point where the doctor hangs dynamite around his neck. And he says, is this some radical new therapy? So I think of that when these guys are, you know, when it's that intense. I think of Bob Wiley and is this some radical new therapy?
So you are saying that we need to detach our sort of emotional investment in this and just stick to the process.
Yeah, and watch this. Once you realize, when you have the conviction of what's really going on, their intensity is groundless. And so you know it. So you're not faking anything.
Yeah.
But you have to have your own conviction for that. I can't, you know, no one's going to be able to give it to you. But it's there to be had.
So yeah, I appreciate that. That's really important. Like you elaborated on that. So the other part
Is the technical element of it.
technical is
Right.
when they do appear not even to be giving you the opportunity to voice things, to say, right, Mr. Smith, you either pay this or not, what are you going to do? There's two guys stood behind you with
Yeah.
guns or whatever.
Right.
What do you do?
Okay, there's a couple of things. One is, so I don't know what I just said that he came over the top. So I would say, well, I've said it before. Well, I'll say it again. Second notice. I don't know what it is. I'll waive that. I'd like to waive that. And if he comes back a third time, I'd say, now, you have to split the conversation. into the matter at hand and the rules of the game. And so once you're aware to do that, you say, now you're talking about the rules of the game, and you say, I've mentioned this, I brought this up twice, and you haven't rebutted point by point. It appears to me that we have an agreement. Do you see how that's absolutely outside of the flow of the conversation? But you need to know, once you know notice, fault, and default, that's how that plays out conversationally.
That's very important, isn't it? As you say, to split it, not only technically, but also in your own perception, to say the matter in hand and the rules of the game.
Mm-hmm.
Because, of course, the other part of this is that when you approach a judge and attorneys or whatever, this is very unorthodox then, isn't it? A lot of people are going to be looking at each other and think, what the hell's going on here? Who's this guy? What's he talking about? This is very strange.
I have some opinions there on that. And the other is, once, I think maybe a judge or magistrate identifies that you're playing by the rules and you're playing by the game and your game is good, that they'll appreciate the gamesmanship of it. Why do they want to railroad? Finally, we get some guys that they're not belligerent, but they're reasonable and they're bringing forth something I can work with.
So you have to be clear, you have to be respectful. There's no point in losing your temper or saying anything stupid. It almost falls more to you to keep it rational and balanced than them.
What's the first 5 words of courteous?
Course.
Yeah.
Okay.
C-O-U-R-T. So, and so the other concept is, if you are just getting railroaded and you've done your notice, fault, default, you've done the, it appears to me we have an agreement, and you keep getting railroaded, there's another way to say, well, then it appears to me that I need to respectfully request leave of court for a judicial review of due process. Right? This is.
And they'll respect that.
I don't know, but that's your next line of defense.
So just like the
Right.
attorneys would say, Your Honour or Sir or whatever, we need to just go and have a talk about this and come back later.
Well,
Anyone can do that.
a judicial review of due process means I don't think you're handling it. I'm going to go talk to your boss.
That's very provocative, isn't it?
Yeah. A due process violation to a judge is huge. Yeah, that's what they're there for. They're not.
That's a fine line, though, isn't it, between, and this is an issue that keeps popping up for me in contemplating these matters, admittedly from a theoretical point of view, but there's a fine line between just sticking to your own knowledge of the law and the process and standing in your honour,
Yeah.
and being entirely, unconcerned about the judge and the attorneys, and the other side of it is just willfully almost just steamrolling them.
Right.
And saying, I don't care how many times you're going to shout, I don't care how many times you're going to try and demean me or be aggressive, I'm going to stick to it. Because I know, speaking with 1 or 2 people about this, people just say, pardon the language, fuck them, just do whatever you want, say what you want, stick to your guns. It doesn't matter how aggressive, how angry the judge gets, it's irrelevant.
Watch this. I had a judge get angry with me. And that's not speculation, that's the word he used. And I said, well, isn't it true that a matter must be expressed to be resolved? How can you skip past a matter and go right to anger and not give you an opportunity to resolve the matter? So let's talk about where the anger is coming from. And he doesn't want to do that. But that's a maxim of law. A matter must be expressed to be resolved. So there's that parenthetical. There's that. We got to talk about the matter at hand in the game. And the gamesmanship. And so that's one. And then the other is, let's just say you get steamrolled in court. There's Federal Rule 9 here in the States, but it's, you just find whatever the rule is in any Anglo-Saxon administrative, that you have 3 days to make corrections in contracts. And you engage in a contract, you have 3 days to annul it. And so, yeah, we got a little feedback.
I was just going to ask everybody, if anybody has their cell phone on or anything that's
Oh.
the problem. Just make sure your cell phones are turned off, because it does interfere with the wireless mic a little bit.
I'll just say one other thing real quick too, is that I guess on the stream, people are saying they are kind of having a hard time hearing this mic. I was just moving the speakers around and trying to adjust that a little bit. But so anyone who else can ask questions and use this mic, let's speak loudly and clearly, okay?
Well, some people weren't even near it at first, so
Yeah.
it's been fixed.
Hold it close, too. Hold it real close, so it doesn't pick up.
So the other thing is you have 3 days opportunity to correct mistakes or to void contracts, and that's what you're going in, is to create agreements, right? And so you can always get transcripts of the court and just cross out whatever you wished you didn't say and make corrections right over them and turn them back in and say, here, that's what I meant to say. And now you can rehab that conversation perhaps under a little more controlled, less intense environment. And that's...
Okay, so just looking at the theoretical side of this again, if you get steamrolled and perhaps you make a mistake,
Mm-hmm.
you don't know the law well enough, and you know it's somebody who hasn't got your depth of knowledge, and you get a ruling against you, what recourse do you have? Let's say in a minor case of like a traffic ticket or something like that.
Mm-hmm.
Is that it? Is it over, or can you say, well, that's okay, now we start another administrative process?
Well, that's a lot of heartache for a traffic ticket. I mean, that's super easy to fix. You just accept the thing and send it back to them. Yeah, I agree. Settle the account. But let's say it's something maybe a little bit more, they want to trip you up for possession of marijuana or something. Oh, I don't know. Yeah, you just take the transcripts and write in whatever it is that you wish to have said, whether it's challenging jurisdiction. I mean, you needed to have already solved the case before you get there. You can't go in and have it out. You have to have...
That's very important what you just said. Because a lot of people do think, again, part of your role here today is to
they do.
recalibrate people.
I forgot.
Thinking,
Yeah.
That's right.
Right.
So people go in and think, let's go and settle this in a court of law.
Uh-huh.
That
Right.
phrase, and that's not what we're doing here, is it?
Let's distinguish court from trial. You're holding court every time you interact with them. And so trial is, let's come in and test out and see which side of this conversation, let's adjudicate the record that's been happening. And people don't see the value in the conversation they're holding outside of that specific public venue. So, yeah, trial is the recognition in public of what's happened. And court, you're holding court every time you interact with them. Out in the hallway, right when you get there, whatever paperwork they send you and you're silent to, yeah, that's court. You're holding court. And so when you're kind of aware of that and know that there's all your powers getting this stuff done up front in advance, and when you go into trial, that's just to have what you've done recognized publicly. That's all that should be for. And if you wait till there to do it, you've already gotten beat because the other guy knows it. If you don't know how you won, you didn't.
So you don't even set foot in there until you know exactly
Uh-huh.
what the result you want is.
Right. Yeah. Yeah.
I've heard that in order for you not to get steamrolled in court, you have to convene a court of record.
Uh-huh.
Was that any truth to that? Because otherwise, if you don't convene a court of record, the record is really a private matter, and the judge can decide not to look at that.
Acknowledge it. Yeah. A court of record is in counter-distinction to admiralty, which is what a court wants to run in. They want to run in a special maritime procedure. And a court of record is, it's just a different set of procedures and processes. And so if you go into a typical courtroom and you follow a lead that they set, that's a different skill set, and it's just different technical data that's out there. When you go in and you want to hold a court of record, you're holding court over the top of theirs. That admiralty court keeps going on, and you're holding one too, sometimes, depending on the situation. And it's a skill set that you have to have entirely. In other words, you can't fill in gaps where you know to with the court of record. You have to be able to do a court of record start to end. You have to know. You have to really know it in depth. It's just a tougher skill set. It's kind of easier just to, because you're holding a separate court. And you adjust things with writs of errors and not, what's it called when you, at the end of court and you didn't like the way it goes and you want it reviewed later? Appeal. Yeah. Maritime stuff is appealed, and courts of record are, the equivalent is a writ of error. And so you have to know how to do a writ of error, and you better be ready to hold the judge in contempt, because they'll want to steamroll. And your check to that is you need to, if they do that and you hold them in contempt, you better know why you're right.
We talk a little bit more about that and the process of holding the judge
In contempt?
in contempt.
Well, I don't want
Should
to.
that be necessary?
Yeah, I don't even want to get into that.
Okay.
No. Partially, mostly because of how low my skill is. I don't want to, perpetuate misinformation.
Okay. Understand.
Yeah. And it's so serious, right? I mean, you don't send, hey, go try this. Let me know how it works out.
It's not something you do just for the fuck of it or for the fun of it.
No.
Right off the bat.
No.
You would use that responsibly in the case where it actually happened.
Hey guys, watch this. Yeah, that's good jackass show.
Yeah.
Yeah, I don't want to be around.
So that, in your opinion, course of record, we should hold that until we get a much better understanding of this whole process.
Yeah. Yeah, you start with I would say start with understanding a writ of error and work your way backwards. Right? Because that's ultimately what you're going to rely on and resort on. So the longer you are exposed to something and learn it, and your most exposure would be whatever you start with first. Man, I'd want to know all about writs of error and exactly what a record is. Admiralty courts very heavily rely on contracting, and it's the last thing said is the topic that we're talking about, and other concepts are abandoned as you go through the conversation. And in a court of record, everything is considered in whole. This was said, then this was said, and that's it. There's no back and forth interaction that gets buried.
So you also said that this court could be held like out in the hallway with anybody you're talking to.
Yeah.
Is there something that you would need to do to officially begin this court? Is there some statement you would need to make to whoever you were interacting with? Or
That's your
is it
choice.
just the fact that they are representative of the court or the corporation or the entity that you're dealing with?
We're holding court right now. No, court's just what's going on. Now, watch this. There's a maxim of law that says he is not to be believed except under oath. And so when you know that, it's your choice as to whether or not to accept informal communication. So, give you an example. If I had a little coffee stand and I wanted to sell it to you, and in this room, all these are just real solid witnesses as to what happened, and I said, "Man, this thing's a gold mine," and you come back to me a month later and you said, "I didn't find one gold nugget." What's up? No pans or nothing, no sluice boxes, and all these witnesses say he said it was a gold mine. Well, that's not literal. And so that's where is someone to be believed? When is their word admissible in this procedure. And so that's up to you. And there's something else that we have never known enough to know what our right is to not accept something that's not under oath. And so, you know, if you're being challenged for something, and let's say a pseudo-criminal thing, you know, you just say, hey, I'm going to have to you're going to have to swear you in, or I'm going to need to see an oath done in front of a proper, you know, court officer, and under penalty of perjury. I'm going to have to see that under oath. Are you willing to do that? Or are we just talking here? Is this just a gold mine? You know what I'm saying? So that's how you make that distinction.
Okay, so here's a scenario for you. So I'm interacting face to face with this entity, whichever it is that I am having this issue resolved in some form or fashion. Would it be advisable to, if it came to another level, it'd have to be his word against my word. So it would be advisable, especially if you're intentionally going to accomplish something in this format, to record it in some fashion?
Oh, sure. Yeah. Yeah, but what's said by, you know, whoever, someone that might be your adversary is, it doesn't have any weight if you don't want it to, if it's not an oath.
So probably none of that would get resolved in that actual setting. It would have to be in the registered oath type format to actual have quote unquote legal resolution.
Yeah, I mean, maybe we might have to talk about this on the side. I think I'm kind of getting lost in your.
Yeah, no problem.
We're being general in a specific scenario.
Okay, something else that I've noticed, and I've looked at a few of these different guys doing real similar to what you're doing.
Mm-hmm.
And something that I have noticed is that it almost seems like there is a certain amount of vagueness that has to be, that everybody's using. And I'm wondering, is this because of the possible legal repercussions upon the guys that are putting this stuff out? Or why are they treading so thinly on that thin ice? It seems like they're walking on thin ice with this material.
Yeah.
And they're very, very cautious and very careful with their words.
Okay, I don't know. I mean, man, that's intent on somebody that's hypothetical, but here's something that the only thing I could say to that is, if you were to look at what they were saying with an eye towards, are they trying to keep this as a variable so that anything can fit here, sometimes seems vague. But what they're trying to not do is limit the concept. And they're trying to just say this, you know, they're saying this is kind of like it's like an X in algebra, right? It's just a variable that, or the word thing, you know, can represent whatever you want it to. So I don't know. Maybe look for that.
Yeah, I was just like wondering if maybe you could speak on, are there any things, so let's say somebody wants to try accepting something for value, is there anything they should be looking out for, like surprise repercussions, such as maybe someone from like the U.S. Treasury showing up at your door?
Yeah, it could. And that all comes down to, you better know why you're doing what you're doing. If you just copy the what, yeah, you could get hurt. And now, you know, who knows? I mean, I have no idea what the possibilities of it are. But, you know, there's probably a lot to know in terms of enforcement, knowing why you're doing what you're doing. Yeah. What property it is that you're exchanging is really what's important, and that's your time, effort, and energy. So, you know, once you know that that's yours, and why is anybody else asking you about it?
Would you say it'd be important to really be clear on why you're accepting something? As in, like, you know, if you're trying to just say, well, I don't want to pay this bill, so screw you, versus I am taking care of it.
Yeah. Yeah, I don't get that specific. Yeah, I try to keep the conversation as small as possible. conversation with a creditor, someone that's in a creditor position.
Well, I was just talking like for yourself.
Oh.
Like, to be really clear for your own motivations.
Yeah, I don't know. I only know why I do it. You know, just if somebody's got an account to zero out, let's take care of it. Okay.
I don't know where to go, but.
I can't know much more than this. We've got to be hitting rock bottom here pretty soon.
Do you have any of your other experiences, Spencer, that you wish to share with us, or in this sort of forum?
Just commercial results and that kind of thing.
Yeah.
Lots of little debt stuff. I had one thing that went away in one notice. I didn't even have to do default, or man, I didn't even send in a negotiable instrument. Somebody was getting leaned on by a major car dealership for about $20,000, and so I sent off a notice, and they didn't know a thing about what was going on. And I asked about it about 6 months later, and they said, "Oh yeah, that just went away." And they used to call daily. And so I guess the other thing in terms of maybe success commercially, because that's where I've spent all of my, most of my time and vast majority of my interest. You know, it's not as much of the court stuff, although I ultimately thought, you know, I better be prepared, you know, if it comes to that. But, and it just kind of interested me. Not so much that I was bracing for anything, but with the commercial processes, it's not over till you're done. It's not over till it's resolved to your satisfaction. My buddy John one time was very dissatisfied with some shoes he bought, and he called up the mail order company, and he said, "I don't know how many lines you got coming into this place, but this one's mine." And so his point was, I'm staying here till it's resolved. And if you kind of go at this with that, where you're comfortable with the pace and rhythm that it's going, and if you know you'll take as long as you want. Now you're in control of that, and you don't have as much anxiety. If you're anxious for something to be over with, you're out of control. Someone else is in control of it. So if you know, you just know, keep at it till you get it right. Gives you a lot more conviction, I would think. Yeah, let me think about some specifics. I kind of like to, I don't know, I've done very little for myself, and so I don't want to be, you know, talking about other people's stuff. Yeah.
Okay, I got a tangent on our conversation.
Yeah.
You know, the Supreme Court came out with the corporation as a person ruling January 2010. And I'm just curious what your thoughts are on that. Did the Supreme Court have the authority to do that?
They didn't declare it. I mean, in other words, it wasn't by their authority that maybe it was something that was recognized. Yeah, corporations have been. God, I thought that was long-standing information. Is that to give you an example, when trusts were first being formed? I mean, man. Talk about hundreds of years ago, more than that, and you know, and it had rights and duties and standing, and that's a person. That's why a corporation's called a person, because it kind of needs to. You know, the word person is. I should have finished my first thought. It needs to have some kind of standing as a separate entity. That's what they're for, and so a lot of the problem isn't that they exist; it's that we don't know how to operate in them. You know, we're too ignorant. Once you kind of start to see how these things work, and that they don't have all this power over you, and they're kind of handy for some stuff. You know, how do you have a bunch of people without a corporation produce something like airplanes and Boeing, right? I mean, they're useful. Just sometimes they get out of hand. The term person means character. So if you look into and kind of envision in your mind, character is kind of like in what capacity is someone right now. And so, yeah, kind of roll that around and kind of see that in your mind, and it makes sense that, I don't know. If you would have asked me what year that was decided, I would have guessed 1800s.
Wow, really?
Yeah.
Well, I find it fascinating that you know, you're sort of falling back on the language itself
Mm.
in the response. That a person is a character.
Mm-hmm.
You know, where most people that don't own corporations, obviously, would not describe a person in that fashion. And
Mm.
so, you know, it leads me to wonder: did we as a culture change the meaning of person, or was that legally established at some point?
Man,
I don't know if you know
that's
the
a
answer to that, but-
that's a Latin term. I mean, it's my understanding that that's been the case since, you know, the Roman Empire.
So you know, obviously, we're not corporations, or maybe we are. I'm maybe ignorant on that, but
Well, you're not a character, right? But you can act in the capacity of one. Tom Cruise isn't Maverick, but he was that character for a little while. So in this capacity, he fills in. In other words, if someone in here was a judge, that's not what they weren't born as a judge and they just always are. It's just that's their character in certain roles sometimes. Yeah.
right.
Yeah, so when you go in as a, you know, whether you're a maybe you're a driver, that's the character you're filling in for. There's that variable there, driver, until someone comes in and gives it life. So, I mean, there's maybe some of the start of. Do you know the difference between the meaning of a word and its definition? You can't get the meaning of a word out of a dictionary. A dictionary may have its version of a definition with multiple entries. But only another man or woman can have meaning. This is what I mean to say. And so I have an idea in my mind, and I'm limited by my choice of words that I would like to use to relay that thought to you. And so sometimes words get used out of context a little bit, or we use euphemisms or you know, that kind of thing, and there's the meaning. And so I can't determine what a word means when you use it with perfect certainty. So.
I got one question about there's also a Supreme Court ruling recently where they, I guess, reinstated or declared the individual rights of each individual and states, that they're sovereign beings and they're individual sovereignty, you might say. And, you know, with full rights, I guess, to the constitutional rights, all the, you know, it's a whole big write-up of the whole thing.
Huh.
It was unanimous, all nine said, yes, you know, we are acknowledging individual sovereign rights and state rights.
Yeah.
You know, and, you know, at the same time, what I also find out too is if you claim your constitutional rights, does that put you in some kind of a bracket or?
Yeah, I think it does.
Really mess with you?
I haven't studied a lot on the Constitution, but I think that there's probably some misconceptions there. I just say I claim all rights and waive none. Why do we got to call them something? Anytime you use a word to say what something is, we're making it specific. You know, which is up to interpretation. But all is it's not very ambiguous.
Yeah, I was just wondering, because in the planning commission meeting, I stood up and I told them, I said, I want to make this really clear. Are you saying we have no right to privacy, we have no right to assembly, we have no freedom of speech, and we have no right to practice our spiritual beliefs? And they actually said yes on the record.
Wow.
So,
Yeah.
you know, I don't know if that was the right approach, but I was just curious to hear the response to that, because their rules and regulations are directly, you know, the Constitution supersedes all other laws
Yeah, yeah. And here's something else too, is once there's an organization, you know, a society that that all agrees to function in a certain way, that contract, that agreement to function that way is stronger than the rights that you inherently had. It is like you work for someone a corporation that has proprietary knowledge, and you learn this technical knowledge, and in advance you signed a non-disclosure agreement that's valid. For this example, it's valid. You can't then go talk about it and say, hey, I got freedom of speech. It's a constitution. Contract is stronger than, you started out with these rights, but you contracted away from them. You agreed to it. And so talk about going back to sovereignty. Who is a judge to say you can't agree to something? That means that he had more authority over you than you did. And so for you to be able to contract away rights is the direct evidence to show you how much rights you have. I have so many rights I can give them away. So, but that means you can reclaim them too, right? If your ability to contract and your sovereignty is that strong, hey, we can correct those problems as well. So we got to know how and why to do it.
So we talked a lot about being in debt and how to sort of get ourselves on the more comfortable side of that scenario. And now my question is about creating new things. There's a lot of innovation and inspiration in the way that people are going to be serving other people. There's going to be a lot of new people becoming entrepreneurial, creating a very unique service. So in that respect, a person who wants to build something that, with this as a foundation, what are the main things that they need to know about, I guess, protecting themselves and creating something that's going to flourish and have its energy go in the places that person is really intending it to?
Wow. I don't know. Understand your right to contract and make agreements and to be able to enforce them.
So like my ideas are sort of expanding the idea of what it means to exchange energy, going beyond just monetary and really opening doors for people to barter, to you know, just however it is that people can create a way to exchange that energy. What are there anything that is there anything that you really need to know about that you might run into with the government shaking their finger at you and saying no, you can't?
Yeah, boy, that's to anticipate something that broad, man. By whose authority? I don't know. Have I contracted away from that? I mean, that's right back to agreements. Do you have authority over me? Is there a guardian-ward relationship I didn't know about?
So say you're making income, say you're actually still involved in, you know, monetary exchange and all the, you know.
Whose money?
Whose money?
Yeah. You mean like Federal Reserve notes?
Yeah, exactly, like cash.
You know why it's illegal to destroy them and deface them, right?
Why?
Because it's not yours. And so while you use somebody else's property, aren't you obliged to go by their rules?
Yes.
Yeah.
So basically.
Know the rules.
Okay.
Or contract back out of it. Send them a notice. Hey, I'm using your bills as if they're mine. No, I'm just, you know what? I'm being facetious. I probably shouldn't have said that. But, you know what you're getting into. I forgot that camera's on.
So a person that I think everybody here knows is Mike Tellinger, and he's really sort of spearheading contributionism.
I've never heard of him.
You've never heard of him?
No.
Oh, yeah, we must have put stuff.
I might know his material. A lot of times I'll know, I will have heard somebody and didn't know who they were.
But it's basically the concept of not using money, you know, and completely removing it from our reality in a really awesome way. So, I mean, do you foresee anything, I guess,
I think that there's a big difference between not using money and not using somebody else's money,
Yeah.
which he might be trying to solve the second one by not using any.
Yeah, just on that point, I was talking to someone the other day. There is this little town in Italy, I don't know if you've heard of it, and they were so kind of pissed off with what Berlusconi was doing with, you know, these austerity measures and stuff. Recently just had been downgraded by Standard & Poor's or Fitch or something. And this little town, you know, very proud, hard-working Italian rural village, has said, right, well, sod you then.
Yeah.
We're going to separate ourselves out from this, and they've actually started printing their own banknotes as opposed to Federal Reserve notes.
Yeah.
And the picture on the note is of this guy who's a community leader, you know, and they say, right, let's use these instead.
Yeah.
So I suppose part of the question that this lady is asking is that doable? If we all decided that we're going to create, you know, consciousness notes or something. With
Yeah.
a measure of, you know,
It happens all the time. There used to be a Cascadia right around here. Here's the problem with that is that there's some folks right over in downtown London that get real upset when you compete with them. So, you know, man, you better be ready for a battle. So is it valid? Yeah. Are there lots of ways to do it? Yeah. Will they cheat, lie, and steal? Yeah. Mm-hmm.
so you can't just clearly separate out and say we're not using money anymore. If you do that, you're going to expect to have some sort of conflict, right?
Yeah, well, I mean, to say you can't means somebody else is going to stop. I mean, there's some regulation that will prevent you, but can you without catching the attention of some people that don't like it? Probably not.
I read this science fiction novel once, and there was some sort of Holocaust or whatever, and we're all starting again from scratch. And they used bottle tops, and that was the trade.
Yeah.
The trade. And they said, you know, if you got some of these, and then they started having banks that held them. And the irony of the novel was that the whole system started reconstituting itself in a very negative way.
Oh, yeah.
But instead of it being Federal Reserve notes, with these like Coca-Cola bottle tops.
You know, since the 30s, the monetary system has had incredible potential. We just don't know what it is yet because we're passing around claim tickets that's a claim on property. And we don't know what the property is. It's just our time, effort, and energy.
So, as you said, the Federal Reserve notes are different to promissory notes.
Yeah, it's a note.
People, you know, 1997, 300 million Americans don't appreciate that. They don't realise it. Even for myself, it takes a bit of getting your head around it.
It does.
This isn't valuable. It has no inherent value.
Intrinsic.
Intrinsic value, yeah.
Yeah, who cares? Yeah.
And yet, you know, if somebody hands you $1,000 in cash, you go, woo. You know,
Right.
You still kind of play along with that. So the point that, I mean, Michael Tellinger is kind of like a esoteric archaeologist, really, so perhaps you haven't heard of him for that reason, but he has started talking about this contributionism as part of his work now, so I'm sure we can look you into that information, you might find it interesting.
Mm-hmm.
But I've seen a few cases. There's actually one in Montreal. It's an artistic embassy who declared themselves independent from Canadian government, and they don't use money at all, and they're kind of getting away with it because they're not interfacing very heavily with the outside world. But obviously, at some point, you're going to need to purchase something from somebody. Where those two systems cross over.
They could purchase, they just might not be able to buy.
Okay, back to terminology again, aren't we?
Yeah.
What do you mean by that?
To buy something is an even exchange of property. If I want to trade you a horse for my cow, it's very equitable on both sides of the values in both. And historically, if I were to give you, let's say, a gold coin that we both agree is par value for that horse you want to sell me, we just exchanged property evenly. And that's buying is when there's an even exchange. To purchase is to acquire by any other means, however you got it, you know, as long as it's legal, except for inheritance. And so that's, Federal Reserve notes or, just claim tickets. However you wanted to do it. There wasn't.
I like leading tickets. I like that.
Yeah. Their intrinsic value was inequitable. It was just legal tender.
So we were listening to Brandon, what's his name? Brandon Adams.
Yeah, Creditors in Commerce.
And definitely don't quote me on this, but he, in one of his paradigm shift videos, was mentioning something along the lines of if a certain number of people were to adopt this philosophy of creditors, that we would then be able to go into corporations and sort of, re-posture ourselves and actually be able to, instead of having corporations look like cancers,
Parasites.
having it become, by us stepping in and having a say on where these resources are directed, having it turn into something that looks more like a flow chart.
Mm-hmm.
And so I just wanted to hear if you had any, elaborated thoughts on that subject.
Yeah, a lot of times people very much perceive corporations to have power and authority over them. And so the created can't be greater than the creator. And so if man created corporations, then man has authority over corporations. And one of the things that I kind of got hung up on for a little while is, but I didn't create it. It's somebody else's. Maybe there's a corporation and James is the creator. So he might be over it, but I'm not. And then I kind of started to roll the maxim around in my head. All men are created equal. All men are equal under the law. So all of a sudden that's where that thing fits, is in that hierarchical created creator scenario. And so if man's on top and they're all equal, why does one have more privilege than another in regards to that corporation? Or how can it, might be a better way to put it. And in light of that maxim, I don't see how it can.
So what's the hypothetical process to that actually becoming a reality of a certain number of people doing this? Would they have to come together with a collective intention and go into, say, a large corporation as a group?
Well, no, you don't understand them yet. And boy, I don't think I understand enough to entertain that question either. Yeah, I don't think he means literally going in and marching on Coca-Cola. Taking it over. You know what I mean? It's just...
I'm just really interested in that.
Yeah, and I have not seen his videos. I have heard him talk on that, and I would say I probably understand what he's saying poorly.
So you get him out here too?
Yeah.
Do you know anything about converting Federal Reserve notes into lawful money?
To like buy gold, something that's intrinsic?
No, so that if you convert Federal Reserve notes, for example, you get a paycheck from your employer,
Uh-huh.
and you're writing back with it, redeemable in lawful money,
Yeah.
pursuant to Title 12, Section 411, I think it is.
Yeah. Give me some gold.
And then you deposit that.
Yeah.
Then that money is not taxable.
Oh.
Because you converted from private property to lawful money.
Yeah. Yeah. I wouldn't care if they taxed it. Okay, here.
And they also can't use fractional reserve.
Oh.
What's it called?
Yeah, the principles of fractional reserve. They can't put it in
You can apply fractional reserve on
it doesn't affect their reserves.
Right.
Yeah. I don't know. Yeah. I don't know. Once you kind of see where the property is and what property is. Yeah, I don't care about whether it's inherent in the gold itself or where it's at. I probably would need to take about an hour and a half or 2 hours to set up money.
You know anything about?
So, with the Federal Reserve notes being property of Federal Reserve,
Uh-huh.
and with there being like money of account and money of exchange,
Uh-huh.
is the Federal Reserve notes money of exchange?
Uh-huh.
So then, is money of account, does that fall under the same like, is that also Federal Reserve notes? Or is that just-
Not at all.
Okay, so that's not property.
Not at all. Well, let's not go that far yet. Money of account is it is something that you have a justifiable reason to put on in a double entry bookkeeping system. If somebody owes you money on a contract and you enter that into your books as an asset, it's just something, maybe it's paper and you just wrote it down, but they really owe it to you. I mean, it's legit, and it's an asset. That's money of account. It's only an idea. And a lot of that's digital, right? The money you have in your, if you get a direct deposit in your account, there was nothing of substance, not even, let alone intrinsic. There was nothing of substance that exchanged. It was the digits that went back and forth. That's money of account. Money of exchange is tangible. And then there's a third kind of money, which is the intrinsic. It's gold, silver. But yeah, money of account and money of exchange are definitely different animals. Give you an example, for a mortgage, you sign a promissory note. The bank takes it in the front door, puts it out the back door, and sends it to Treasury. And Treasury monetizes that for $300,000, and then sends it Fedwire to that bank. That's money of account. And it doesn't actually exist yet. And then if you say, hey, I want to withdraw $1,000, it's converted the same way you might envision U.S. dollars being in a foreign exchange conversion. Except that we don't really perceive that because it's always one-to-one. It's the same thing in our mind. Well, value-wise, yeah, but it's not the same thing.
Just a very practical question. I've just been kind of following this news story recently that Bank of America has started charging people $5 a month to use their own debit card from January.
Yeah.
And Chase have been trialing that, and they're going to do it, and probably all the big banks are going to do it due to this. I think it's called the Durbin ruling, which is like if you go and buy a pack of cigarettes from the general store. And on the credit card, like some money goes from the retailer to the bank for that.
Mm-hmm.
And they're just lowering that amount, which benefits the retailer, so they get more.
So they're trying to make up for it.
So the banks are trying to make up for it by passing it on to the general customers.
Yeah.
Just as a practical issue, as we're talking about money, do you have any personal thoughts on, is it wiser for one, as we still have to use money at the present moment? I mean, I don't know many people who don't. Is it wiser to go to like a credit union, which is a bit less profit driven, a bit less corporate, or what?
Boy, I don't know. You can set up fee schedules, and so you say, hey, every time I have to pay $5, I'm going to have to go ahead and charge you $7. So I hope you don't mind. Here's my notice. Here's my fee schedule, and all that kind of stuff. So what's good for them is good for you. What they can do, you can do. There's all kinds of stories out there of. There's a guy named Ben Lowry that interviews several people, and one guy goes by the Spaniard, and he's great. And he makes a living. But no, I don't know. He knows of people that do quite nicely collecting money off of those kind of scenarios where banks are getting out of line. And he says, well, guess what I charge? I'm going to start charging for fixing your mistakes, and here's a bunch of errors. And if I call you up and I expect to talk to a live being and I get a recording, I need to get $50 for that. And he establishes an agreement with them. And yeah, there's all kinds of remedy in the small claims court if you keep your fee schedule reasonable enough.
And they abide by that.
No, they get their teeth pulled out. I mean, the judge says, yes. Yeah. Maybe, you know what? He did say some of them have just paid before it's gotten that far.
He said a lot of them did.
Yeah. I think I retract no on that, and I'm going to have to go with yeah.
So does he just use silence on their part to say that they're agreeing?
If they do, or probably dishonor. I mean, if they argue, they don't have standing yet until they're point by point relevant and unambiguous.
And then, like, to set up a fee schedule, can you just say, I have a fee schedule, or do you have to actually?
Oh yeah, you got to give them fair notice of what it is, and it's got to be within reason.
But you can just, like, notice them in a letter and you just decide.
Why couldn't you? Yeah. Yeah, watch that one. If you look up Ben Lowry and the Spaniard, I know it's on YouTube.
It's the latest one, too. There's a few Spaniard on there.
Yeah, right. I would say it's newer than 6 weeks.
Yeah, it's probably within the last month.
Yeah. Hey, can I get transcripts of this so I can correct all my mistakes?
Yeah.
Okay.
Yeah, you got 72 hours.
Okay. Good, I'm going to need a couple of pens.
I was wondering if you could just talk a little bit generally about the administrative process, which I understand to be a basic three-step process.
Yeah.
Different components of that, but just to help give people a basic understanding of what the administrative process can be.
Yeah, the administrative process is the back and forth dialogue and exchange of I say, you say. And it can't be endless. We can't go on and on and on and use attrition and wearing someone down as a ploy or method. So it's over time, or wherever we're at now, it has been reduced to and generally accepted that this three-part process that you're talking about, or due process, it's part of that, is notice, second notice, or another way to say that is fault, and then default. Sometimes I'll do third notice. Sometimes I'll do notice after notice and second notice. I'll do intent to default and then default. So I'll do 4 sometimes, especially on mortgages. It's either Federal Rule 50 or 55 or 60 that's in there that kind of indicated that even though that's a statute, within that there's a principle of someone needs to know that they're going to be defaulted. And then there's your record. There's the court. Back to the difference between court and trial. And then trial is now the venue for this three-part process to be heard and to be made a fit. Maybe you did it wrong. You know, maybe you didn't make proper presentment. Maybe you didn't give them all the information that you should have. So that's the three-part process that I think you're asking about. My take on it. I don't think I know much more than this.
I think you did.
Let's say you messed up on something in that process and you didn't realize it, and then you go to trial and they say you messed up in your process. Is that like end of story for you, or is there some remedy that you can do?
I don't know enough. It's probably not, and they probably wouldn't tell you exactly where it was. They would just, not find for you. Probably what would happen is if both parties were in the court, whoever was administering that would probably give the other party a second bite at the apple, see your flaw in due process, and explore it with them right there on the spot. And then if it was it didn't have an effect on the process, or he was satisfied that, however it was decided with the default is still consistent, or who knows? But that's part of what that live hearing's about, is to, okay, well, here we are, let's see if you can take care of it now. It's also a good opportunity to lose your 3-part process. If you talk too much, you talk over it, you lose it. You could.
The more I'm learning, the more I realize I don't really know anything at all about this whole process. So it's kind of,
That doesn't go away.
it's big. But I do know that the only way to really do this is to gain some experience.
Mm-hmm.
And so,
Sue Nate. Sue Nate.
yeah, right. Well, practice, and we've been playing
Winston
around.
says that. He says, hey, just sue your friend.
Right.
Who does?
Spend $100. I've heard Winston say that.
Yeah.
Go get a great education for $100.
Right.
Oh, that's good. Yeah.
A college education, I think he says.
Wow. But I do have these opportunities here to start a process, and at what point, I feel like I'm never really going to be ready. I just need to start one.
Mm-hmm.
Which types of opportunities are the best ones to start with to practice on? Maybe suing a friend. Okay, that's one. But I have some real scenarios here that I can play with.
Yeah, I would say wherever there is the least attachment to the surety. By surety, I mean collateral. Collateral is not a very good word for that concept as we use it, but let's say if you have a car and you're still making payments on it, they could come repossess it. But if you have some old medical bills, see, what are they going to do? Come back and take away your flu shot?
If you did get a flu shot, then hopefully they will take that away from you.
Ideal.
Go back in time so that you don't have that flu shot.
Ideally, I know, but I couldn't think of something. Are they going to come repossess your surgery? Right?
I hear you. Okay. What do I have to lose here?
Right.
The smallest.
Yeah, wherever there's the least surety at risk. Sometimes if you want to do this with an open credit card account, I'd be real surprised if they didn't shut it off. If you want to do this with a current open utility bill, game on. They'll probably shut you down.
Cool. Well, Spencer, it looks like we are nearing the end of the tape, and we've been going for about 3 hours. It's probably about time for us to go take some lunch break.
Yeah.
So I do want to remind anybody that's on the stream, we're going to be back here probably around 5 o'clock-ish.
Don't those guys have questions?
Dave? Well, I don't know. We didn't really get to any of those. Or actually, I guess there wasn't any on the stream. So.
Oh.
But yeah, so we're going to be back around 5. Hopefully Dean Clifford is going to be joining us via Skype.
Yeah.
And Spencer can jam out with him. We can all jam out together and ask questions and discuss. And so it'll be a good opportunity. So tune back in at around 5 o'clock. But Spencer, do you have any closing remarks for us, or any other encouragement or advice for people who are just getting started with this stuff? Maybe some references they can check out, or just general words of advice and encouragement?
Follow your own questions, right? Instead of just shutting your brain off and wanting someone else to dump the knowledge into you. And probably follow Bob Wiley's advice and don't get caught up in the conflict that they try to get you to bite into. Just stay cool. Is this some kind of radical new therapy?
Awesome. Spencer, thanks for coming out here, man, and sharing your time and your knowledge and your wisdom.
You're welcome.
And your experience with us.
Yeah.